We don't bite. Thank you all for coming to our session. I actually wanted to go to the other session that Erica Wilson is on, but I was like, I guess if I'm the moderator, I have to show up for that. Just kidding. But thank you all so much for coming and joining us for this, what we hope is a really fruitful discussion this afternoon. So we call this Moral Panic and Moral Dilemma, Critical Race Theory and the Reckoning of Our Democracy. And what I'm going to do is provide a little bit of an overview or context for our conversation. We will actually be touching on quite a few issues. Students are required to sit front and center. No, I'm totally kidding. I'm totally kidding. So we'll be touching on quite a few different issue areas and also quite a few different interventions in the law. I actually, and I'll formally introduce myself. My name is Janelle George. I'm an associate professor of law at Georgetown Law, and I'm the founding director of the Racial Equity in Education Law and Policy Clinic. And in the clinic, students engage in legislative advocacy. So we're not your traditional litigation clinic. And we work on issues of racial inequality in education at the federal, state, and local levels. And so this has included work, which I'll talk a little bit more about during the panel, in Virginia, throughout Virginia, supporting English learners and undocumented students. This has included federal advocacy work, writing comment letters in response to proposed regulations, writing policy briefs, research briefs, a variety of use of legislative tools and interventions. And so we're going to start with having each panelist give a brief introduction of just themselves, what issue, where they work, what issues they work on, and then I will provide, again, some opening grounding context for us, and then we'll kick it off delving into some education issues. But again, we're going to touch on a few areas. So education, immigration, democracy, political participation, etc. So let me hand it first to Kara. I don't know why the sound, okay, there it came back. I'm going to hand it to Kara, who's online, to introduce herself.
Hi, everybody. I'm so glad to be here with you, and especially to be with former LDF colleagues who I always love to see. So I direct the Advocacy for Racial and Civil Justice Clinic at the University of Pennsylvania at Carey School of Law. We are a clinic that does civil rights, impact litigation, and policy advocacy. We use a movement lawyering frame, which means all of our cases or advocacy projects are brought to us by grassroots partners locally here in Philadelphia and in other parts of Pennsylvania. And I will leave it there.
Hello, everybody. My name is Jin Hee Lee, and I am the Director of Strategic Initiatives at the Legal Defense Fund. This is actually, I think, I'm going on my 18th year at LDF, so I've been there for quite a while, mostly doing litigation in the area of death penalty, criminal justice issues, death penalty, juvenile life without parole, policing, and then more recently started doing work in the education space. I led the team that represented the student and alumni organizations at Harvard in the SFFA case. And more recently, about 3 years ago, I was tasked to create a new department at LDF called the Strategic Initiatives Department. And what we do in that department is house very discrete and very strategic initiatives that bring together all the advocacy tools that we are lucky to have at our disposal. So, and I'll talk a bit about the initiatives, when we get to my part of the presentation. But it's really exciting because we're creating teams, for example, of a litigator, a policy advocate, a community organizer, a comms specialist, and then also the researchers at our Thurgood Marshall Institute, which is our research institute, which Carla can talk a bit about. But this is kind of how we're engaged in some of the advocacy that we'll be talking about today.
Thank you. My name is Carla McCanders. I like to say now that I'm not in academia anymore, I'm a recovering academic after 20 years of teaching and running an immigration clinic. I now work with Jen Healy at the Legal Defense Fund where I run the Thurgood Marshall Institute. It's the in-house think tank at LDF, where we have social science researchers and a team of archivists that are working on preserving history, doing research that supports the Legal Defense Fund's advocacy projects in education equity, the criminal legal system, economic justice, and which one am I forgetting? Political participation, which I can't forget. We were just at the Supreme Court. So I think that's mine.
Wonderful. I just want to do a mini poll just to see who you all are in the audience. So students, current students, raise your hand. Woo! Yay, current students. One else? Oh, wow. Y'all need do you have a mentor? Okay. Professors. All right. Okay. Advocates, staff. All right. Organizers and others. Welcome. Welcome, and thank you so much for joining us. So, obviously, we've been focusing so much on critical race theory. All of you are aware of all of the attacks, right? This false moral panic, if you will, about critical race theory. But as so many folks have been saying, both last night and this morning and at this afternoon's panels, CRT is actually the very analytical tool that can help America reckon with its unjust past and chart a racially just future. CRT recognizes that America's past is not too distant from its current reality. In the last text that Martin Luther King Jr. wrote before he was killed, called Where Do We Go From Here, Chaos or Community, he said, no society can fully repress an ugly past when the ravages persist into the present. And so we see these through lines between what's happened in the past and how the law has been unfortunately leveraged to promote inequality and what's happening today. So the Fugitive Slave Act of yesteryear echoes in today's anti-immigration policies, ICE raids, right, which are fueled by racism and xenophobia, slavery's denial of education for enslaved and some free Black people, manifests now in the intentionally segregated and under-resourced schools that we see across the country in which Black children are relegated to, in large numbers Black and Latino children. But CRT really instructs that the past is prologue and that cycles of inequality perpetuate, right? They repeat unless they are intentionally interrupted. And at bottom, these tactics of racial oppression, past and present, seek to erase the power, perseverance, and political participation of Black people and other communities of color. So CRT can help us not only expose this agenda, but also provides us with a blueprint for building a more racially just democracy. That's why it has both long been a target, again, is seen in this current moral panic against CRT, which we saw near the end of the first Trump administration, and now these attacks against DEI and other equity projects, right? It is really an emancipatory tool. So we know that Christopher Rufo, who is a conservative activist, really led this moral panic and made CRT basically this receptacle for anything considered to deviate from the white patriarchal norm. And as Kimberly Crenshaw has noted, times of perceived racial progress, so the multiracial demonstrations and solidarity after the killing of George Floyd, are often quickly followed by backlash and racial retrenchment. We see the Civil War, we see Reconstruction, we see redemption, we see the Civil Rights Movement, we see the evisceration of affirmative action and other efforts. So CRT recently has been this cover for all conservative grievances, so-called wokeness, the so-called stolen election, affirmative action, DEIA, all of these things, right? And so this really has opened the door to what we're seeing now, right? ICE raids, people literally being disappeared on the streets, voter disenfranchisement and intimidation. and blatant disregard for procedural and substantive due process. So this is how we are going to kind of scaffold our discussion. And again, it is a discussion. So students get ready. Just kidding. I will quit harassing you all. But we do want you all to engage and discuss. So each of us is going to touch on some different components or tenets of critical race theory. And this is the reason why we're doing this. And Erica Wilson, who is on that other panel happening right now, but she has said, if you use the wrong frame for understanding the problem, then you'll come up with the wrong solution. So it is important for us, again, to use CRT as a tool to frame the issues that we're examining. And we're going to critique not only these issues, but potential tools and interventions and strategies to help transform the law to better promote racial justice and secure a future for viable multiracial democracy. Education scholar Nalaway Brooks, I think she's actually a sociologist, and she wrote a book called Integrated, noted that we can either be coroners or we can be surgeons. So we can examine what has contributed to what we're really witnessing, the death of our democracy, but we can also surgically and strategically figure out and help work to cure these ills, right, that threaten this democracy. So each of us will touch on 4 key questions. How did we get here? What are those through lines between the past and what we're seeing now? What is actually happening in these different areas? Then we'll talk about what we're doing about it, right? This is part of what a panel this morning called this kind of reconstructed project of critical race theory. What are we doing? How are we helping to address this? And then we'll also talk about what you all can do about it, right? We're all very differently situated, but there is potential for advocacy and intervention no matter where you're situated. Oh, that's a lot. Okay, so I'm going to just briefly start, and I'm going to be quiet so you can hear from the other panelists and not just me. I'm going to start with the issue area that I focus on, which is public education. And I don't know if we did mention, I think Kara said this, but we've all worked or currently work at the NAACP Legal Defense and Educational Fund. So when I came out of law school, I knew I wanted to do some kind of public interest law. I did not know what that would look like. I went out to Washington, D.C. I interned with the Children's Defense Fund. And then I did a fellowship at Georgetown Law called the Women's Law and Public Policy Fellowship. And I was intrigued by this idea of public policy. I had no idea that as a lawyer you could go and be legislative counsel for a U.S. senator. I didn't know that was a job, and that's what I did. So I worked on Capitol Hill. But when I came to LDF, that's when I started to center my advocacy work at the intersections of race and education, and I realized that education touches on so many different issues of inequality. That is why it has been weaponized from the very beginning to maintain racial caste and racial inequality because of its power, right, and its potential. So I want to touch on the CRT concept of colorblindness, which I think is really instructive for understanding educational inequality. And as most of you all know, proponents of this idea of colorblindness refuse to acknowledge, first of all, the history and current impact of racial inequality in this nation, and they also refuse to acknowledge how laws like racial caste laws or Jim Crow laws were actually race conscious, right? These were about race. And so instead, they have this ahistoric approach and understanding of American history. And so now what we're seeing is they equate race-conscious interventions to remedy past discrimination with racial caste laws, whites-only laws. And so, for example, if we consider laws that bar the consideration of race in student assignments, those have been legitimized by the U.S. Supreme Court. But the logic undergirding those efforts, which again equate any kind of race-conscious efforts, right, whether it's discriminatory or remedial, we're now seeing those being actualized, right? Those kind of racial subordination laws were invalidated in Brown. right? But now the Supreme Court is twisting that logic and basically further advancing or entrenching school segregation and racial inequality in America through executive action. So we see parents involved in 2007. That was a K through 12 case in which you had two districts, Seattle and Jefferson County, Kentucky. They had these voluntary diversity efforts. Jefferson County was originally under a school desegregation order, but they continued their work, diversity work, on a voluntary basis. The Supreme Court said you can't do this unless you're under a desegregation order. You can't do these kind of voluntary race-conscious diversity efforts. You can only do things that are considered quote-unquote race neutral, which we all know this whole idea of racial neutrality in many ways is a fallacy, right? That logic opened the door for what we're seeing, unfortunately, happen now. It became a mischaracterization of the Equal Protection Clause. It became a mischaracterization of the Brown ruling. The whole concept of equal protection has been co-opted and weaponized to re-entrench racial inequality. And so, again, we're witnessing the actualization of that kind of race-neutral logic. And I believe that what we're seeing is what I call federal neo-segregationism, right? So we have an executive now, at least by theory, Brown is still good law, knock on wood. But oh my God, is that a sign, y'all? But the executive is acting as though it is not good law. And then the absence of Plessy versus Ferguson being law, right? The separate Plessy, which validated this idea of separate but equal. And actually a little bit different from even what we saw with massive resistance to Brown. What we're seeing is not just states and localities defying federal court orders or legal precedent and promoting segregation. We're seeing the executive actually lead the charge in promoting and entrenching segregation. So what's happening? I do have a framework that I came up with, and I'm wrapping up. I know I only have a couple minutes. If you need help going to sleep, it's called Deny, Defund, Divert, The Law in American Miseducation, Georgetown Law Journal. I think it's like issue 112, something like that. So I call it Deny, Defund, Divert because I think that you can categorize a lot of laws that seek to entrench racial inequality as those that seek to deny access to education, defund public education, and divert both people and funds out of the public education system. So let me just share, if I can buy 2 minutes. Okay, I'm buying extra time, sorry. Let me just share a couple of examples and then I'll move it on so y'all can hear from other people. So denial, we're seeing the denial of access to truthful and full curriculum, right? Through a lot of these so-called anti-CRT measures, et cetera. Defund. Cuts to the Office for Civil Rights in the U.S. Department of Education, right? To be clear, there was already a backlog of over 20,000 discrimination cases when Trump took office in January. In March, the department closed 7 of its 12 regional offices, laid off half of its staff. And also I want to remind folks, it's weird because when you live in D.C., you feel so close to these issues. Our government is shut down right now. It is shut down. Now, there is a law prohibiting eliminating positions during a shutdown, but it's the Trump administration is still trying to do that. I think a federal judge placed a halt on any more terminations while the government is shut down. So the Individuals with Disabilities in Education Act, or IDEA, that includes $15 billion for funding for students with disabilities, the $18 billion Title I program that serves districts serving high numbers of students from low-income households. All of these programs and funding are being gutted. So 121 employees in the department that serve special education are being impacted. So what does this mean? There's no federal oversight. Where's the federal oversight and accountability for students' civil rights, right? And to be clear, these offices were created via statute, mainly Title the Civil Rights the Civil Rights Act of 1964. Folks forget we didn't have these kind of infrastructure. So I call this the federal civil rights infrastructure. It's being eviscerated. It's being completely eviscerated. So where's the accountability? Where is the oversight? TRIO, which is funded about $1 billion to support veterans and college students from low-income families. That program was gutted. Oh, look, you're adding time now. No, I'm really gonna stop. But also, the last one I want to mention, a program that's being gutted, is called the Fostering Diverse Schools program. This gave funding to districts that wanted to voluntarily pursue diversity. That has been cut as well. And diversion is, the administration is trying to divert agency functions that have been housed historically in the Department of Education, which actually has been around, you all, for quite a while, since the 1800s. President Carter did make it a cabinet level agency, well, the statute passed in 1979, but 1980 it became a cabinet level agency. But pre-1980, it largely, they just collected data. After it was elevated, it really did become an oversight and enforcement agency. But unfortunately, we're seeing that eviscerated. We're also seeing diversion out of the public education system and infrastructure through vouchers and charters, which, by the way, are partial scholarships. A lot of people think of vouchers positively, like in New York, if you get a child care voucher, it's a great thing. A voucher to go to a private school, you get a partial voucher. You've got to come up with the rest of that money. And a large number of families who are able to do that are middle class or upper middle class, right? So what am I doing about it? Legislative advocacy in the clinic that I mentioned, that I'll talk a little bit more about after other folks share. And then I'm going to hold on my thoughts about what I think others can do after other folks have shared as well. I am going to transition it. Actually, I am on time. Okay. I am on time. I'm going to transition it to Jen to touch on some of these other issues and talk about what she is doing at LDF.
Thank you, Janelle. So just so everyone knows the subject of my presentation, it's going to be covering, and some of this is building, a lot of it's building upon what Janelle shared, but just the proliferation of this false narrative and ahistorical narrative about racism in this country, both past and present, which has led to this subversion of our equal protection and anti-discrimination laws, all of which undermine the whole concept of a multiracial democracy. And we're seeing that kind of unfold, as the days go by, right? Maybe even taking a step back, I am an example of a practitioner, a lawyer who has applied the concepts and theories of critical race theory in actual litigation and actual advocacy. I do not come from academia. I've taught a few classes, but I think that the whole notion of critical race theory being something that is, left to professors and people to think about in an abstract way is completely false, because I'm an example, and I know many others, my colleagues, are examples of how we are trying to bring the ideas and the lessons learned from critical race theory into practice as we advocate on behalf of Black communities and other communities that have been disadvantaged in our country. And for me, it was wonderful learning about the origins of the critical race studies program here at UCLA, because it started in 2000, which is the year that I graduated from law school, and I wasn't lucky enough to have this wonderful program. It's just now I regret where I applied and where I went to law school, but I did have the benefit of taking advanced equal protection from Kim Crenshaw, and I will say the most formative there's a lot of law school that I've forgotten, but the one class in law school I've never forgotten was a critical race theory seminar with Kendall Thomas, and I always think back to the readings and the conversations that we had in that class. And the reality is that everything we discussed in class 25 years ago is happening today, right? Because one of the first lessons, and we've mentioned this before, is this false dichotomy between law and society, as if there is any possible way that our legal structure and our laws could be objective or neutral in any way. And the prediction that critical race theory has always said that if we do not consider the structures of systemic racism, then we are going to be perpetuating and in fact reinforcing racism throughout, as we continue trying to engage in kind of creating a more just and equal society. And that is very much happening right now, right? Because the dominant theories that are kind of applied by our Supreme Court, textualism and originalism, are very much grounded in this notion that you can look at the Constitution, you can look at the laws in an objective way, right? That's not outcome, predictive, right? That somehow there is a neutral and objective way to think about how certain white men in the 18th century thought about these ideas, and somehow that would allow us to be objective in how we interpret the Constitution. And that, in many ways, and the way that our entire legal structure is reinforcing and has perpetuated this kind of false narrative that we are dealing with right now, which has been kind of exacerbated. And one thing that I've been thinking a lot about is how in litigation, because I'm a litigator, and you go into a court, that the burden is on the plaintiff to prove that there is discrimination. Like the default, the status quo is that there is no discrimination, and then the plaintiff has to prove that there is discrimination, right? As opposed to the defendant having to disprove it. And this is the downfall of not having disparate impact. Because if you have disparate impact, then it's of course expected that there would be racial disparities, because we've had, our country was born out of racism, and that the very people who were subject to that racism are the people that are suffering from the racial disparities. It doesn't take a genius to make that connection. So, okay, defendant, explain to me why this isn't a part of, systemic racism, but instead it's on the plaintiff. So that in itself is establishing a false narrative that a court, with its kind of, its authority, right? It's this kind of institutional authority, is perpetuating throughout society. So that is the reality of being a civil rights lawyer engaged in race discrimination litigation. We do have certain statutes that recognize disparate impact, but they are currently at risk. We all know this with the Supreme Court, and it's no coincidence, right, that the extremists, the anti-civil rights extremists, are going after disparate impact because that is the reality of it. It doesn't, it's very much at odds with the false narrative that they are trying to establish and cement in our country. The other thing that's happening too is that it's no coincidence that the attacks that these anti-civil rights activists are kind of targeting, they're targeting public education. And this goes back to Brown v. Board. And one of my favorite lines from the Brown v. Board decision is that public education is the foundation of good citizenship. This is the place where you have children from all walks of life, all income levels, all races, all backgrounds, coming together, learning shared values. These are the people who will grow up and become voters, right? These are people who are going to be participating in our political process. And to kind of convey to them, what does it mean to be an American? What does it mean to be, a member of this country, this diverse, very rich, but very, sad history of this country, right? This is why we have history classes and so forth. And the legal terms that have been, if you've been following these executive orders that that President Trump has been issuing, there's been these kind of new terms like divisive concepts and racial scapegoating and things like that That was actually in an executive order that he issued at the end of his last administration in 2020. It's Executive Order 13950, and it targeted DEI trainings, with federal contractors and federal grant recipients. After he lost the election to President Biden rescinded that executive order on his first day in office. But what happened, in 2021, is that state governors took that exact same language and applied it to state legislation. So everything that you're seeing right now happening at the federal level has been happening in Alabama, has been happening in Texas, has been happening in Florida, Oklahoma, all of these states since 2021. And they took this language, not going after contractors immediately, they took this language and they put it in legislation targeting public education, K through 12 and higher ed. And what does that lead to? That leads to censorship of curriculum. So now we have states where it is prohibited to have certain conversations about racism or sexism in this country because we have to have more patriotic language about how we teach about our country. I mean, we have situations where, reading Ta-Nehisi Coates' book is against state law. Like this is, there's been situations where, reading about Rosa Parks is against state law, or recognizing African American History Month is against state law, because that has been defined as divisive and discriminatory, exactly what Janelle had said about subverting the whole concept of equal protection and anti-discrimination to actually vilify the very activities and the very language and information that is meant, that is what's meant to try to advance racial equality. We've also seen suppression of protests. That, especially in student campuses, that is no coincidence. That is where you have this has been a long tradition, right, in American history, that students exercising their First Amendment right to protest, to challenge the government, challenge people of authority, to help, they're in a place of the sharing of ideas and of scholarship of all people. Students should be able to express themselves and to be able to, challenge the status quo and really think critically about how we're looking at certain kind of policies or laws and so forth. And not only has this been kind of a prohibitive, like banning or prohibiting certain information or certain kind of speech, but affirmative attacks against people of color and disadvantaged groups. We've seen that, again, with the federal government in terms of their investigations and, executive orders against public universities and private universities, the grant terminations, the incredible fear of students being able to engage in protest or to even engage in kind of student activity that tries to advance or even acknowledge that there are differences or different experiences based on race or ethnicity or gender identity or sexual orientation. Let's not forget that as well, because the intersectionalities. I mean, there's this kind of tremendous vilification of transgender people that again is as a part of this effort to kind of change our history, change what the facts are, and then also. And this is something I think that is really, when talking about affirmative attacks or affirmative dangers, is this kind of weaponization of the term domestic terrorism. And that has been something that is not new. This is something that has been a part of prior administrations of using the power of the federal government. And this, I think a lot of this was created in post 9/11, right? The creation of a comprehensive surveillance system to dehumanize and vilify certain groups of people because of their race, their ethnicity, their religion, their communities, creating a system of mass surveillance, government violence, and racial profiling. And let's remember that those are all the elements of our law enforcement system that has always been in place, that has always been a source of violence against Black people in this country. I mean, the whole concept of law enforcement was created because of slave patrols and of trying to control as social control over black people. So we are creating an infrastructure that would very much go hand in hand in perpetuating this, mass kind of law enforcement system that throughout history has never, has always been a source of violence against black people. And, I think, to sum it up, this is all meant to kind of neuter the Reconstruction Amendments, right? The whole idea of the Reconstruction Amendments was to ensure that all people, but particularly black people in this country, would be full and equal citizens. Now, not citizens as in like a citizen of the United States, but to be exercised, to have the privileges and the benefits of being a full person in this country. And all of these efforts are very much, what's happened since then is to kind of undermine that vision of equality that was inherent in the 14th Amendment. Am I running out of time?
No, you have 5 minutes.
Oh, okay, all right. Well, so let's I'm going to hurry up because we have alternative facts, revisionist history, some examples. I think we all know these. The next year is the 250th anniversary of the Declaration of Independence. All kinds of, false narratives going to be happening there, and with the Smithsonian and so forth. Things that we've been very concerned about. The thing that I've been thinking about a lot is that the logical conclusion of what is happening is the validation of Plessy v. Ferguson. And what I mean by that is that the whole concept of Plessy is that there is a difference. There's like legal equality, and then there's just, life, right? And some people are smarter than others, and some people just, choose to live with certain, this whole idea that there's a difference between that, right? And that has allowed a situation where, and that was something that was supposed to be condemned. The idea that for black people, for example, that they should be second-class citizens, that they, the fact that they are segregated into certain schools, or that they were not able to access certain opportunities, that in itself was something, as Brown would say, that there's a stigma associated with inferiority. That if you want full equality, people have to have full equality. Everyone has to be seen the same. But if you follow the logical conclusion of where we're going in terms of the law, like say, for example, affirmative action is now, it's not fully, but essentially obliterated, then if there is, an elite selective university that happens to be almost all white, then that's just a natural occurrence. That has nothing to do with, pre-existing discrimination or barriers that prevented Black or Latino students from accessing that. I mean, what does that mean as a country? Are we saying that it's perfectly natural for our country to be segregated racially as it is, right? And that itself is reaffirming the racial stereotypes that we are supposed to be trying to eliminate, and allowing the court to kind of validate that. What am I doing? I guess maybe I don't have time to talk about what we're doing, but we do have very specific initiatives at the Legal Defense Fund that are attacking all of these things. Yeah, so we'll try. I don't want to, kind of take too much. I knew this wasn't enough time, and then maybe I'll talk about the recommendations as well. But the one thing that I do want to emphasize is the importance, and we talk a lot about diversity, and I always, especially now, I really encourage for people to talk about it for diversity in the same sentence as inequality. Because if there is no diversity, we're not seeking diversity for the sake of diversity. We are seeking diversity because if there is no diversity, that means there was inequality, right? It's meant to kind of to undo an unjust situation, right? To remedy some sort of inequality. And but in that spirit of it's important to have diversity. It's important to have the best, all kinds of ideas and diverse perspectives kind of interacting with each other, because we need everybody. I also think of that in terms of different disciplines. So we need scholars, we need organizers, we need policy, we need all kinds of people like thinking together, because, if you have lawyers just doing it, they're just going to do it the lawyer way, and that is not going to be all of it, right? If you have just organizers doing it, this is a time for all of us to kind of benefit from the expertise that different people from different backgrounds can bring. So I will now hand it over to, Kara? Okay, great.
Yes. I just wanted to say thank you, Jen. Let's give Jen a round of applause. I just wanted to say briefly before we transition to Kara, for the benefit of our 1Ls in particular, disparate impact, which I don't know if you've touched on yet,
Oh my God.
is when a this is a technical definition, right? Correct me, Jen. When a otherwise facially neutral law or policy has a disproportionate impact on like a protected class, right? So say you have, I don't know, a school dress code policy that says that anyone who wears their hair in cornrows, like cornrows are prohibited. Well, with a few exceptions, who would that impact, right? Right? So it's also kind of like the, when something's just not quite right, it's kind of that. You can't put your finger on it, but something's just not quite right about a lot. That's what disparate impact is. Is that right, Jen?
Yeah, that's yes.
Okay. Now, Kara, we'll hand it over.
Thanks, Janelle. You actually couldn't have teed up better what I was hoping to talk about, because I am going to talk about school discipline, the history of how school discipline moved from being a more explicit attempt to reinforce white supremacy to being seen today as race neutral, despite the fact that the history provides the context for us to understand why it is in fact still discriminatory and rooted in this historical enforcement of white supremacy. And so I'll start just with the question of how did we get here? So we've I can't say it better than the two past panelists have already. I'm just going to briefly, not repeat, but emphasize a couple points, because I think it's going to be relevant when I talk about our Penridge complaint that the clinic has brought. So, what we're dealing with is, of course, as Janelle already eloquently spoke about, backlash to the progress and really the movement in terms of hearts and minds that happened post-2020 in the aftermath of Mr. George Floyd's murder, where we had the largest protest movement in history, and DEI initiatives, affirmative action policies, etc., passed by nonprofits and education settings and corporate settings across America. And so what we're seeing is the backlash from that in terms of conservative organizers finding a way to, through the boogeyman of CRT and most recently now the boogeyman of DEI, to push back against some of that progress. And we know that the Heritage Foundation has been core to this. In their Project 2025, they've released a blueprint of policies for the next administration that specifically called on the president to dismantle DEI apparatuses across federal agencies. But really, as we've already talked about a little bit, we're not talking about DEI, we're not talking about CRT. We're talking about a return to white supremacist social order. And core to this agenda has been the undermining of civil rights laws, anti-discrimination law. DEI may be the term they're using, sometimes CRT when we're talking about understandings of institutional racism. But really, what they're focused on when you look at the policy changes they're making is really undermining the 14th Amendment and Title VI, amongst other anti-discrimination law, which I'll talk a little bit about later on. Of course, this is also happening in the context and the climate where a conservative supermajority on the Supreme Court has already indicated its willingness to defy precedent and to endorse a colorblind interpretation of the Constitution. All of this has only emboldened conservative activists to push for even greater restrictions on civil rights and racial justice progress. So of course, this attack on racial justice is overwhelming. But anyone who has studied civil rights knows this is not the first period in which progress is quickly followed by backlash. We've already touched on the way that Reconstruction was followed by the nadir, racial terrorism. and within the courts, the civil rights protections that had just been gained becoming hollow promises for really a century until we had the second founding with the civil rights movement. And so in a recent piece I have forthcoming in the Clinical Law Review, I argue that really now is a critical time for law students to study the Reconstruction Amendments. And I hope that for the law students in the room, you will really take to heart what we're saying, because for so long, this history of Reconstruction and really history of abolitionist thinking that shapes the Reconstruction Amendments has been kept at the periphery or even excluded from mainstream legal education. And now I think we can all in this room see why it should be central. I actually teach a course in addition to the clinic that's called The Unfinished Work of Reconstruction on the Reconstruction Amendments. And a lot of what we learn about there is the abolitionist thinking, both through grassroots work and through legislative efforts that have shaped the Reconstruction Amendments. And in particular, we spent a lot of time talking about Du Bois's idea of abolition democracy. This is the idea that, as Du Bois wrote in his seminal text on Reconstruction, that abolition of slavery specifically, had been achieved in the negative sense, that it had been, through the 13th Amendment, abolished, but that was only a formal legal change. And the concept of a positive project, a reconstructing all of this country's institutions to ensure equal citizenship, was the promise of Reconstruction that was never fulfilled, and that is still what we're dealing with today. The gap between formal legal reform and really the ways that society adapts in response to legal reform through what, as Janelle's already touched on, Professor Crenshaw's idea of retrenchment in the face of legal reform is what we're dealing with. And so I thought I would talk about these themes in the context of some research I've been doing recently, and then in the context of some of the work the clinic's been doing, and then I will wrap up. So in the context of research, I have been studying school discipline. Really, it grows out of my experience as a classroom teacher in the K-12 setting, and then at LDF working on school discipline, this persistent pattern of racial disparities across the country and exclusions through suspensions, expulsions, etc., that is just so pervasive. And that I think many people would be surprised to know has existed not just since through zero tolerance. A lot of times we talk about the school to prison pipeline coming to birth in the 90s with zero tolerance policies, but actually that it dates all the way back to the 1960s, the early 1960s. Many people would be surprised to know that prior to the 1960s, suspensions and expulsions actually just weren't used at schools. Very insignificant numbers of suspensions happened. And actually the use of suspensions really coincides. We start to use suspensions in significant numbers when school districts begin to desegregate. So we're talking about the 1960s, to be clear, instead of 1954 with Brown, because it takes another 10 years for meaningful desegregation to begin because of massive resistance, amongst other things. And so it's not until mid-1960s that we really start to see school districts have to, through court orders, desegregate, as essentially LDF is going around school district by school district litigating cases and getting these consent orders put into place. And so it's in the early 1960s that we first start to see suspensions and expulsions happen. So what's the connection? Why is this happening? Well, actually at the time people realized what was happening. And so there was a report released by the Robert Kennedy Foundation, the Southern Regional Council Foundation together. And the report was called The Student Pushout, Victim of Continued Resistance to Desegregation. And what they found, they looked at the school districts under desegregation orders and found that in those districts, large numbers of minority, mainly black students, were all of a sudden being suspended, expelled, and as they called it, induced to drop out in these mainly desegregating school districts. And at the time, we're talking about significant numbers. In some school districts, it's a third of black students. In some school districts, it's a half. And so those numbers sound high, but the overall national numbers are not that different from today when we look at the disparities. And so why has there been this consistent pattern, right? The SRC, or the school, the Southern Regional Council, argued that it was because they were trying to evade these desegregation orders. And one of the things that I read and looking back at some of these reports was that there was some school districts that this was a common thing that would actually put up dividers in the room when their classrooms were by court order forced to desegregate. What they would do is literally, I know this sounds so basic, but it's true, they would put up dividers within the room and say, okay, white students on this side of the room, black students on this side of the room. So when you think about the attempts of evasion that were as basic as this, it shouldn't be surprising to us that there were more sophisticated ways, right, that school districts came up with for, again, responding to formal legal reform. And so the Southern Regional Council defines this effort as what they call the student push out, this idea that black students were being pushed out of these districts that they were just gaining access to. And it becomes really a movement. LDF convenes a group of national civil rights organizations. There's a series of additional reports. It eventually becomes an issue that goes before Congress. They hold a series of hearings. So this I talk about in an article that I just had come out. So I won't belabor these points, but I think there's a number of reasons why this history is really important for us to remember. Critical, of course, out of all the reasons is because it really shows us why the patterns we see today are not just race neutral, but are rooted in a history of specific systems and policies that have a direct link to attempts to maintain white supremacy through formal de jure segregation. You might say, well, right now the goal is not formal de jure segregation, but the link from that history is still critical for us to understand. A lot of times what was happening in these desegregating districts was all of a sudden you would see a toughening of school discipline rules. And the rules were changing and the districts were explicit that they were changing them because they now had to deal with black students and white students being in the same room together. So they changed dress codes, as Janelle was just mentioning. In some cases, they were explicit in saying, well, now we have to deal with the fact that girls are going to be, and this is a quote, they had to be more conservative, one district said, with regard to girls' dress because black and white boys and girls were now attending school together. That was a school district in South Carolina that went on the record saying that. And in many cases, the offenses that students were getting suspended and expelled for were things that had to do with enforcing a racial social order, like black boys whistling at white girls, like black students not saying yes sir or yes ma'am when responding to their teachers, and other students not receiving the same discipline for it. And one example that I think is really poignant, if folks remember the Little Rock Nine, there was a student named Minnie Jean Brown. She was experiencing, as were all the students in the Little Rock Nine, racial harassment as they were integrating the school district. And she actually, in one instance, she was suspended because as a group of boys were following her, teasing her, she accidentally dropped her chili bowl, and after that was suspended. On another, the chili dropped on one of the boys, and she was suspended for that. In another situation, she came back and again was being harassed, and she lost her cool and responded using an inappropriate word, as the school district called it, towards the student who was harassing her and teasing her. And after that, she was suspended and ultimately expelled for the remainder of the year to never come back. So that's just an example of how push-out was actually playing out at that time. So what does this have to do with today? One of the things I talk about in the article is the Department of Health Education and Welfare, which later would become the Department of Education. This school discipline issue, which becomes the subject of a series of hearings that Congress held, it nearly becomes the reason that they began defanging and defunding Q at the time and taking away its enforcement power. This was ultimately unsuccessful, but of course you can't help but think about how this effort has continued today with the Department of Education. But second, I think more generally, this is in a lot of ways a microcosm for thinking about how subjective policies are used more generally in all different areas of law, of criminal justice, of other institutions where we know there is ongoing racial disparities that have their roots in a more explicitly discriminatory policy. And so the question in my mind becomes, if we haven't dismantled the infrastructure that has its roots, does it matter that the purpose is not the same as it originally was if we have the same infrastructure that is still operating and if we know that the bias still exists? And so more generally, I think, as we've already touched upon, this is an example of why we have to really study history and understand how the legacy of slavery and Jim Crow, the continuities between policies from the past to today. And really the reason that they want to erase history and don't want us to understand the context is because it is the critical tool for us understanding how things that seem to be not explicitly about race or race neutral are in fact rooted in this history. It provides the context for us to understand society and the patterns of discrimination today. Am I doing okay on time? I'll just touch briefly on some of the work the clinic's doing. No, am I out of time?
No, you can, you're good. You have a couple more minutes.
Okay, all right. I will very briefly just talk about today and what the clinic's doing. So again, what we're seeing is really an attempt to undermine anti-discrimination law, but it's as Jen touched on. It started at the state and local level, and so I want to talk about a case that the clinic is working on that was part of one of the original state and local efforts to disband DEI, and I think it's important that we look back at those now as we're seeing the ways that these policies have become federalized, and of course, right now we're seeing a dismantling of the Department of Education. So I hope we'll get some time to talk about how do we challenge these efforts today, because the tools that were available to us before are just not available anymore. But the clinic represents students, families, and teachers in Penn Ridge School District. Penn Ridge is about 30 minutes outside of Philadelphia. And when I started teaching at Penn about 4 years ago, founded the clinic, I was expecting to do work that was different from what I had done at the Legal Defense Fund, because obviously LDF focuses mainly on litigating in the Deep South. And instead, I was finding 30 minutes outside of Philadelphia, same things are happening that were happening in Texas, Louisiana, etc. So in Penn Ridge, it started with, at this school district, post-2020, in the backlash, parents organizing to disband DEI. And I want to share, because I think it's really drives the point home, this picture of what one of our clients was asked to remove. You can see here, it's a bulletin board in the elementary school. It shows pictures of students of different backgrounds or different colors on this bulletin board. And in the months after the summer of 2020, one of the teachers was asked to remove this bulletin board because it offended the DEI ban that the school district had passed. So, again, I think many of us thought, by 2021 that we were at a very different time from today, but this is the roots of how we got there, right? Penn Ridge School District passed a number of policies. They were engaged in book banning that was prevalent throughout all levels of the school district, removing books authored by people of color, in particular Black authors, and LGBTQ plus authors. They had a policy that was a discriminatory bathroom policy. If you can imagine, one of our clients is a teacher who had to walk nearly a mile, if you can believe it, to use the bathroom that was available to him because he is trans, and it required him leaving the building, walking around, and coming back. And so you can imagine he couldn't do that on a lunch break. It just was too far to be able to do that. So he just had to hold his urine all day and eventually left the school district. There were bans on pride flags. There were a discriminatory sports policy that forced trans kids to out themselves to play sports. And then there were these guidelines that essentially operated to a don't say gay policy in discussing students and staff background. And then Penridge also had this long history of students experiencing racial harassment and transphobia and homophobia, and the school district doing nothing about it. So it was a hostile environment that was exacerbated by all of these policies that then got adopted in 2020. And so we represent two grassroots organizations as well as the NAACP chapter and individual students and their families and teachers. We brought a complaint with the Department of Education, and again, we can talk about all of the ways that we are now having to pivot, but I want to bring this up because, you know, it sounds, in a lot of ways, we hear about the defunding of the Department of Education, we hear about the ways that the administration is no longer prosecuting discrimination except for discrimination against white people. We hear about the staffing cuts, the grant cuts, but really the on the ground level impact is that, you know, within the clinic we had to, the morning after the election, talk about, well, what do we do for these clients now? What do we do for each of the individual students and parents who had experienced this severe harassment that literally pushed, in a number of cases, pushed them out of the district, and now our government was not going to be providing a redress for them through the Office of Civil Rights the way they were entitled to through legislation that dates back to 1964. So I know we'll talk more about all of this, but I wanted to just bring up the example of what are we doing now in clinic.
Oh, wait, round of applause.
Before I get started, I just wanted to recognize the brilliance on this panel. These women have been devoting their careers and working around the clock to help us realize our multiracial democracy. And it's the brilliance that they're displaying here that is being pushed back against, because they've done the work and put in the time. As I was sitting here listening to you, I had to say that. I am going to switch things up a little bit. My area of specialization or scholarship is in immigration law. And I've been looking at the intersections of race and immigration law from when I started teaching immigration law, critical race theory, and running an immigration clinic. And I still write in the area, even though I'm at the Legal Defense Fund. So I've been looking at recently how we have this concept in immigration law, it's called immigration exceptionalism, and it allows the federal government to be exempt from giving immigrants constitutional protections. And as I began to think about this concept of exceptionalism within immigration law, I more and more saw that it was the norm. And so critical race theory talks about the normalcy of racism, that the relationship between law and race, especially in immigration law, is the panelists have talked about, where we have facially neutral laws or colorblind laws that quietly, not so quietly lately, reproduce racial inequity. And in my paper that I'm writing, they silence dissent. But this is not anything new. You can trace back the foundation of our immigration laws and our citizenship laws from formerly enslaved people being 3/5 of a person to the 1790 Naturalization Act, which restricted citizenship to free white males. And immigration laws and citizenship laws are defining who belongs in this country, what it means to be a member of this country. And this logic continued through the Chinese Exclusion Acts and the Supreme Court Chinese exclusion cases, saying that Congress could exclude foreigners of a different race because it was in the political branch's discretion to govern matters involving foreign affairs. And this is where this plenary powers and immigration exceptionalism doctrine comes from, that the federal government has sweeping discretion to deny constitutional protections to people who are labeled as outsiders. And over time, this framework has expanded beyond race and to target ideas and ideologies. And so when you have the intersection of race and ideological dissent that challenges the racialized caste system that we have in this country, you see the repetition of using immigration laws to either exclude people who are challenging the power systems in the United States or to silence people. And so this dates back to the early 1900s, where the United States started to deport people who had dangerous beliefs. They were anarchists, labor organizers, and immigrants who questioned American hierarchy. And by the mid-20th century, you had dissenters who challenged racial segregation and were treated as threats to the state. And so you had the merging of race and ideology, where you had non-white bodies and non-conforming ideas that were cast as equally dangerous. Jen mentioned the pattern after September 11th. The Bush administration announced that it would end racial profiling, but it said, and I quote, except in law enforcement activities involving threats to national security or the integrity of our nation's borders. So you again see this concept of, when you have national security or borders involved, that we will not apply the Constitution. And after 9/11, we saw the racialization of Muslims, racial profiling of Arabs, Muslims, and Southeast Asians under this banner of security. And the Bush administration's proclamation, alongside individual acts of violence, led to governmental racial profiling. It created the Department of Homeland Security, the law enforcement entity that was implementing this policy of, when you're protecting Americans' borders, you can engage in racial profiling. And we recently saw the Supreme Court, and what Jen calls the Kavanaugh concurrence, reaffirm this principle of being able to racially profile individuals, because, again, it's an exception. And what I argue is that this is not an exception, it's a state of continuity in the United States. So in this particular moment, we have the historical background. We see that dissent, especially that's sympathetic to Palestinian or Muslim causes, have become suspect. And this isn't a break from history. If you go back to McCarthyism, you go to 9/11, it's a continuation of what we see, that immigration laws are being weaponized and used as a retaliatory tool against those who expose America's racial hierarchy. So what is happening today? Executive Order 14188 was framed as an effort to combat anti-Semitism, but it became a tool to detain protesters, revoke visas, threaten universities to revoke student visas because of the political views of international students. Again, that executive order used that language of national security and American values to punish dissent. And it mirrors an earlier moral panic and moments where the government weaponized neutrality to enforce a racial hierarchy. So this is the same playbook that we've seen before with dissenting voices, and especially those individuals, people of color, are reframed as national security threats. And immigration laws being used not just to regulate entry and who becomes a citizen, but to police belonging internally and ideologically. And critical race theory helps us to see that this is not an anomaly. It's the normal operations of racism through the law as a state of continuity. So what am I doing about it? At the Thurgood Marshall Institute, our work is rooted in integrated advocacy, conducting research, histories. We just built a robust archival project where you can go onto ldfrecollection.org. We are digitizing all of the Legal Defense Fund's records and making them free and available to the public so that we are counteracting the narratives of originalism, originalist history, cherry-picked history, and we like to say with the archive team that we are putting the receipts online for everyone to be able to access. Another thing that we are doing is we participated in the State of the People papers, educating communities about the historical links between the 1790 Naturalization Act and how that's closely connected to the 14th Amendment and how these frameworks still shape who is conceptualized as being fully human and protected under the law. We're testifying before the United Nations on the state of Black migrants and through the U.S. Pretrial criminal legal system. But I think most importantly, we engage in storytelling and reshaping the narrative. We're helping people to see what's often invisible, how these spatially neutral policies disproportionately harm Black communities and undermine our activities as achieving a multiracial democracy. And we always are having conversations about how can we put this into a visualization. I learned the new term scrollytelling because we want to get people, younger people engaged and not reading a dense report, but how can people navigate through the materials that are accessible, that allow them to learn our history, allow them to people to engage with data and to confront systemic racism within our country. Are we saving our how to move forward?
Yeah, why don't we give Jen like 3 minutes to talk about what you're doing, and then we're going to talk collectively about what do we do, how do we move forward.
Okay.
Okay. Thank you, Carl. Round of applause.
Yes. Carla, who's also been a brilliant colleague and scholar, and
absolutely.
Okay, so I'm going to try to do this 3 minutes. I do have more, but okay, here we go. So I think I mentioned that my new department has these integrated initiatives. The one I think is probably most relevant for this conversation is called the Pro-Truth Initiative. We call it the Pro-Truth Initiative, and this was a conversation I think that was in one of the earlier plenaries from a question from Jerry Kong. Because we say that this is not about opinion or different versions of history. This is about truth. A truth that our country was not founded on principles of equality. There's certain truths that we just kind of have to maintain, and so we have been challenging these censorship laws. We've been doing that for the past 5 years. For those of you who are interested in kind of the developing kind of First Amendment doctrine, it is now. I mean, it's a time when the law is developing, and because we've never experienced something like this before in terms of this level of censorship. But I will say this, and I think this is where critical race theory is so essential. When we at LDF, when we have filed these lawsuits, we bring, claims of First Amendment violations, that the law is vague, but we also bring equal protection claims. Because when you think about classic First Amendment law, this is, no idea is superior to the other. Everyone should be able to kind of express themselves. For us, that is not the case. Because this is a situation where this type of censorship is erasure. It is discrimination. It is a way of demeaning and excluding and kind of falsifying, right, the history and experiences of specific people based on their race. And also, again, for other kinds of identities. And so that is something that I think is really essential. Because we're integrated, we've also been pushing back our community organizers, working with families. We South Carolina is not a haven for civil rights advocacy, and yet because we have been partnering with families and grassroots activists, we have been able to prevent the passage of anti-CRT and anti-DEIA law 4 years in a row in South Carolina. There's laws in Alabama, there's laws everywhere, not in South Carolina. And that is the power of, working together. Finally, I think, though, what is really needed, and I this is something that I kind of implore like the scholars and the students and the lawyers, is we have to have an affirmative vision. It can't be just about criticism, and it can't just be about like saying this is wrong, and it cannot be about defending the status quo. The status quo, we cannot, DEIA was never enough, right? That was like that was like the bottom, that was like the baseline. And so that is something that we're also doing. This came from our organizers actually working with the community partners, is working on a student's Bill of Rights. What is it that every student demands that they have in their education to inform an affirmative legislative advocacy. The last thing I just want to say, can I just say one more thing though, is working at the local level. This is something that Carla and I are going to brainstorm together on, but to recapture what equal protection means, and to do it at the local level, to kind of discard what the Supreme Court has said. We can create our own laws. We can create our own concepts of equal protection, but also to be able to communicate it to people on the ground so that it's tangible for them, right? Because when we say equal protection, when we say about equality, that means nothing in the abstract. And too long, it has been in the abstract. It's nothing that people have been able to actually hold on to because it hasn't been fulfilled, right? This has nothing to do with their everyday, problems in life. And so that's another thing that we're working on. And I also just encourage everyone to be working at the local level, not just at the national level. Okay.
Yay. Thank you, Jen. Thank you, Jen. So, Jen, actually, you just started us off on what will be our lightning round. So I will go, Carla and Kara, offering what you just did, which is a couple of thoughts about interventions or addressing. Then we're going to open it up to you all. And not only do we want to hear your questions, we also want to hear if you're working on something that you would like to share, whether it's writing something or some kind of project you're doing, and your thoughts, right, about moving forward. So I have just like two things I want to flag in terms of moving forward. Sumi Cho, who is a critical race theory scholar and works with African American Policy Forum with Kim Crenshaw, is called this righteous resistance. So we hear about massive resistance after Brown. Think of what they did. They said, the Southern Manifesto said they would deploy all legal means to resist a Brown ruling. We need our own kind of resistance, right? Which again, she terms righteous resistance. Using the courts, doing diversity, get sued, go to court, right? The lawsuits take a very long time. Drag some of these out, right? So I practiced family law for a couple of years, y'all. All my students know this because I did not love it. It was drama-filled. It was contentious. It was awful. But whenever I was doing a case and things were looking bad, I had a supervisor who would always say, just make your record. Get things out on the record. We need to do these cases. We're going to lose a lot. I do a timeline leading up to Brown for my students. It's over 100 years old because it starts with Roberts versus City of Boston, right? In the late 1800s, right? And it goes all the way up. We're going to lose a lot, but let's make a record, right? Make a record. And at the very least, those who come after us will know that we fought. And we fought as hard as we possibly could. So that's my answer, righteous resistance. Kara, and then we'll close with Carla.
Well, on a similar note to make the record, I think we need to all be thinking about reparations. And not only for the purpose of compensation and but also for the purpose of thinking through what does repair look like and what was the harm. I think it's a critical public education piece that is needed right now, and obviously reparations task force are popping up on the local level across the country, and some places on the state level, including California. Hopefully one day on the federal level, but I've been serving on the Philadelphia Reparations Task Force for the past year and a half, and have learned so much, and just the process of, as a community, thinking about what is the harm that was done and what does repair look like, I think is connected to this conversation we're having about making history public, making it something that people can access, and forcing people to really have to grapple with it.
Thank you.
I think the Legal Defense Fund over maybe the past year has focused on defending, disrupting, and dreaming. And I want to talk about disrupting and dreaming. As I was talking about the state of continuity, I think one of the things we need to do is make sure that we are pushing back against these narratives, like immigration exceptionalism. That is one of this doctrine of exceptionalism, which is the norm. Like, accepting it as exceptionalism allows authoritarianism to come into power and to stay in place. And so rebuilding from the ground up, we need to disrupt those narratives that paint history as being an exception to exclude Chinese nationals, being an exception to have a travel ban because of national security. Then with the dream part, I think it is really important that, especially for our young law students in the room,
One's
that
left.
you, one law student, there's other law students in here too.
Yeah, thank you.
Yeah.
Thank you.
And Grace, she used to work with us at the Legal Defense Fund, who's a law student now, to really step boldly into this project of using the law as one of the tools to reform our system, to redistribute power, to affirm life, and to uproot these systems of racial control. The thing that I miss about being a law professor is working with students. My students always had creative ideas about, we were litigating asylum cases. How do we shift the narrative so we're not just presenting a victim narrative to the judge to win our cases, but we're recognizing the true humanity of the people that we are representing in immigration court. So I know there's a lot of gloom and doom today, but with the law students in the room, I think you have the power to dream big and step boldly into those dreams. And I'm rooting for you. I'm getting old, but I'm rooting for you, and I know that you have the support in us, your elders, and people at this law school who have created this program for you to do the work, put in the work, and do the studying and dream big.
Thank you. So we can open it up for questions, and I see someone already has her hand raised. I don't think we have a mic, but okay. So we'll start with you, and then person behind you. Sorry for pointing, y'all. And person behind you.
Yeah, I can speak up. I'm a 2L. I was drawn to this panel initially from the first 5 words, moral panic and moral dilemma. Ultimately, I think most of us are looking for a sense of hope, and usually when there is discomfort or when there is some sort of general awareness that there's something wrong, it pushes people to want to fix that, and whether that be a temporary fix or a more long-term one, that's something that we can all work towards. But when you're talking about, for example, a student Bill of Rights, or things that we can do to force young people, the country in general, to reckon with history or the truth that we believe to be true, I think I want to sort of acknowledge that for most young people, the anti-intellectualism that technology has provided and this idea that we can force people to focus on one topic might have been more palatable when everybody was watching the same news channels every day. We don't even have Disney Channel anymore, let alone the idea that we can create a sense of community amongst young people who aren't even watching the news. You don't have that. You have social media, right? So let's say you're making information shorthand. What I'm trying to say is young people, what's the dream that we're selling them? What can we say? How can we tell them that education is important when getting a degree doesn't get you a job? When getting a master's degree and a PhD doesn't get you a job? I think there's an awakening that isn't going to happen overnight, but how can we work within our individual communities and in our individual relationships to try to break the attention span that isn't even there anymore?
I think that you are presenting the ideas for this. I went back to school and got a divinity degree during the pandemic in theology. And one of the core principles that kind of came out of that was what you just said, is like building relationships. And as lawyers, sometimes we tend to silo ourselves in our work, and as law professors, silo ourselves in our articles. But I think it's building relationships. You know, me talking to you and, you know, learning about your generation. I recently was telling my colleagues over lunch that I started mentoring a 12-year-old girl who's in middle school, and I am surprised that she is speaking a different language than me, from 6-7 to clock it, and I think it's, but that's like the start. And I know that sounds kind of floaty, and, you know, but I think it is the foundation of, you know, the multidisciplinary work that we're doing at LDF. I talked about it when I was at Vanderbilt teaching, and how to work with different departments. Jen is actually doing this in her strategic initiatives departments. When she has organizers, she has social science researchers in the room, litigators, policy people, communications team, and they all come together weekly, and they are approaching cases from this relationship-centered perspective, and all voices are contributing to how we solve the problem.
I mean, I appreciate what you said about the cynicism and the frustration of the current moment, and I think that is why it is so essential for organizations like the Legal Defense Fund to be working with young people, because if we're not, and it's you know, I'm a Gen Xer. I do not understand social media. Like, it's a different way of communicating now. And I think and so there's so much for us to learn. But I guess here's some thoughts. I'm not saying I'm an expert, but there is such an outsized emphasis on the Supreme Court, the U.S. Congress, your senator, and if you, I mean, it is incredible. Like, the North Carolina Supreme Court at one time had a Chief Justice who was the first Black woman to be the Chief Justice, who recognized the fact that Black people were being discriminated against in jury selection. It was historic. She lost the election to continue to be the Chief Justice to the only justice that dissented in that opinion by 900 votes. In a statewide, I mean, that was just a few years ago, right? If you look at any local election, there's just a few thousands, right? And you think about this, like your local Board of Education, they decide what your school district is going to be teaching. They're going to decide what the policies are for hiring your educators and things like that. So there is so much potential to influence your local government, and the outsized impact they have on your daily lives. The local sheriff, the local prosecutor, these are all people who are being elected, and you can pass laws at the local level, right? And you have, I mean, that is why I think that that could be an incubator. This is where you can test things out. People can have new ideas and be able to actually implement them, right? Without having the baggage of what's happening at the national level. And actually, it's almost essential to do that, because that builds the foundation. That's what the conservatives did. They focused on state organizing, right? They captured state governments. That's why the Electoral College has become such a, so anyway, so that's I'm personally holding on to that as a kind of glimmer of hope that we can actually push for change in the context of what is, like, realistically, a very difficult Supreme Court and federal government.
Thank you. So much to say on that question, but we will go to the next question. Try to squeeze it. By the way, y'all, we know we're short on time, so those who can stay for a couple more minutes. Those who can't, we will not be offended. Oh, ouch. No, I'm kidding. I'm kidding. We will not be offended if you leave. Yes.
I teach in a predominantly white school system, and so the idea of the moral panic, even though it's national, kind of still found its way to where I was. And there's a little bit of confusion that happens because you're essentially talking about something that is not in your community, right? And using it as it's fear-mongering, but you know, the black and brown faces are far in between. So I bring that up to ask, the policies that you guys are we're talking about and mentioning are affecting those individuals in those communities, right? They're predominantly white, or in rural areas. How do they kind of fit into the discussion? Do they fit into these discussions?
So your question is, in these predominantly white communities where they are implementing some of these, whether it's censorship, book bans, etc., where do they fit into the discussion?
Right, and in implementing those initiatives or policies, it's kind of working against their own interests.
Right, but and I'll respond briefly and then open it up for others. I think we've got to help people see that better, that it's going against their own interests. If people are othering people and looking at through this kind of fearful lens, they're not seeing the connection to their own lives, right? So it doesn't seem bad to ban certain books with black authors if you don't see any kind of correlation to your own life, or if you can't see the importance or impact of that to your overall education, right? So I do think we have to do a better job of helping people see the interconnectedness of all of our experiences and what you're depriving yourself of when you're implementing those kind of bans or laws. I can speak as someone who teaches at a predominantly white law school. A lot of my students in the Racial Equity and Education Law and Policy Clinic are white. And I will tell you, some of my best students have been white students from rural areas, including Kentucky and Ohio, because they know what it's like to be deprived of resources, and they know what it's like to not have what they need, right, for a quality education. So I think as advocates, as academics, et cetera, we do have to do a better job of, again, impacting the narrative. Even when we talk about segregation, people always think of segregated black schools. What about the harm of white children who are also in these segregated all-white schools, right? We forget the Department of State wrote an amicus brief in Brown saying that it is in our national interest to have integrated schools because people are better able to learn to interact with other people. And Kara, we don't want to leave you out of this, too.
You said that well already.
Okay, any other? Okay. One more question, y'all. Everyone's getting extra credit for staying over time. Thank you. Any other?
I just had, if we have the time.
I think we do.
Well, I just wanted to answer that question too, because one of my pet peeves are some communication strategists who kind of encourage us not to talk about race because it doesn't message well. And I always say that it doesn't message well because the other side has succeeded in their communication strategy. So again, we're just responding to them as opposed to having our own affirmative one. But there's another really interesting study that was presented, which I thought was really interesting because it showed that, and they kind of broke people into different demographics and how they responded to like race messaging, right, about racial justice issues. And the ones that were most hostile to it, like saying there is no racial, like no systemic racism, tended to be more like affluent or middle class, like white, kind of, so-called conservative, voters and so forth. Actually, very poor, like people like poor, working class, don't have a college education, white voters or people who are eligible for voting, were one of the groups that was very open to acknowledging, yes, that there is systemic racism, right? That the biggest concern for them, though, the hostility to that, is because they felt excluded. They felt like they were not being acknowledged in terms of so it's just, I think that there are, just as Janelle said, I think what we have lost is the communications game, right? Because we're always responding to the other side as opposed to having our own affirmative truth, right? It is truth. It's not a zero-sum game. That whole concept of a zero-sum game has just gotten so much traction, as opposed to actually, things will get bigger. There'll be more to share, right? If we deal with all kinds of different kinds of inequalities. And so anyway, I just kind of wanted to share that.
Thank you all. Please join me not only in thanking our panelists, but our poor timekeeper who we stressed all the way out. Sorry.